Okay, good evening, everyone. I hope everyone is doing well wherever you are right now, and welcome to our fifth episode of the Strata Talk Show. My name is Amiza, and I will be your host for today's Strata Talk Show. This talk show is brought to you by Excel Academy of Real Estate. And Mr. Patrick will be our guest speaker for tonight's talk show. For today's episode, we will talk about defective parcel and dispute resolution. And if you have any questions regarding this topic, feel free to type your questions in the Facebook comment box below. Hopefully, we can entertain your questions by the end of this session today. And hello, Mr. Patrick, how are you doing today?
All right, thank you very much. Good evening to you also.
All right, okay, good to know that. Okay, without wasting time, let's welcome Mr. Patrick to start the session now. Into you.
Okay, good evening to all the participants. All right, welcome to today's session. I'm glad to be here to share a little bit of my knowledge and experience regarding this particular topic. Uh, if you were to ask me, this is one of the most trickiest practical problems that a lot of residents in stratified properties, especially buildings, which they face. The key issues is about defective properties. One is a property which is defective, that is your own unit which is being defective, and where do you complain to or how do you deal with this defective property. Two is damage which you suffer as a result of your neighboring property being defective. Now, a neighboring property being defective could arise in one of two ways. One is your neighbor above you, that is, the unit which is immediately above you, could cause problems to your ceiling because there could be leakages appearing from there. And if your ceiling is the plaster ceiling type, you will find that the greatest enemy for plaster ceilings is water. You cannot use water. It will cause severe damage to your plaster ceiling. The other damage comes from your neighbor, either to your right or to your left. And this is your wall. There could be some damage arising. Now, so when we talk about these situations, why do I say it is very tricky? It is very tricky, first and foremost, because if you were to look at the Strata Management Act as a whole, the Strata Management Act does not provide for dispute resolution between owners, between parcel owners. This is perhaps one of the most unfortunate things that we have in our Strata Management Act. Now, as a comparison, in the US, right, the management corporation owns the entire building. The management corporation actually does all the repairs. They carry out all the repairs. Any kind of damage, they repair. And of course, they charge it against the parties, but because they are the owners of the building, so they are obligated to repair. Now, what we call as parcel owners here, there you're only a shareholder in the management corporation. This is what the idea of the unit shares is all about. That means for each unit, you have a certain number of shares allocated to you. Your voting rights is determined by that share units. We have the same here in Malaysia, of course. But you are not a shareholder in the management corporation. You own the parcel in Malaysia, but you are a member of the management corporation. In the US, you do not own the parcel. The parcel is owned by the management corporation. You are merely a shareholder in the management corporation. We need to get this clear. So in the US, even if one of your lamps is faulty, you call the MC in, they will come and change the lights for you. If your taps are leaking, they will change it. All repairs, all kinds of defects are taken care of by the management corporation. The only exception is for gas pipes. For gas pipes, individual owners pay on their own, they repair, they maintain on their own. As for some historical reason why it has been like that. Now, in such a situation, any damage to your property is not an issue for you because you just call the MC, they just come and repair and they finish off. The problem is not yours. It's just like if you have a car accident and your car is damaged, you send it to the workshop, the insurance pays for it, and it's all over. You don't deal with anything. Unfortunately, in Malaysia, that is not the case. And so we have a very, very tricky situation. In Malaysia, you are the parcel owner. So the parcel comes under you. When your lights fuse, you need to change your own bulbs if they are internal. If your own pipes leak, then you will have to change them. The MC is not responsible for what happens inside your parcel. So if there is a defect in your parcel, let's take the first scenario, a defect in your own parcel. What can you do about it? First question is, when do you discover the defect in your parcel? If you discover the defect in your parcel when your property is still under warranty from the developer, then you will have to bring your complaint to the developer because it is still under warranty. Now, the catch here is this. Many people who buy, when you go to a developer marketing department and see the model units down there, you're very interested in buying. And when you do your booking, straight away the developer will show you another counter where bankers are there to determine if you can get loan. And further on, there will be still other kind of counters. They will tell you if you want to do renovations, excuse me, if you want to do renovations, you can go and see them. They will do the renovations for you. So let's say right in the beginning, you want to put in built-in cabinets, built-in wardrobes, and you want to make renovations to your place, then this might have the effect of hiding some of the manufacturer's defects. So later, when you complain, maybe pipe leaking or there are cracks on the wall, then a dispute will arise. Is it due to the developer or is it due to the renovations that you may have carried out on that property, which will have the effect of nullifying the warranty to be given by the developer. So a dispute, not only do you have a defect arising, you now also have a dispute arising on that defect. That's your first problem. Now, assuming that you have not done any renovations whatsoever, then of course you can take up the matter with the developer, and the developer will be duty bound to make the necessary repairs. This is their responsibility. This is also assuming that you are still within your warranty period. Now, if on the other hand, the warranty period is over and then only you discover the defect, you need to ask the question, was the defect or the damage a latent defect, meaning while there is a defect, the effect may only be visible months or maybe even years later. If it is a latent defect, then you may still be able to bring an action in court or whichever tribunal you want to bring it to, you may still be able to bring an action there. If you can prove to the satisfaction of the tribunal that this defect actually arose earlier, but it only became visible later. The law has even been amended so that the 6-year limitation period for latent defects is now extended. I do not wish to go too deep into that, but if you attend any of the seminars, we will go into that aspect to talk about how this latent defect thing comes in. All right. Now, if it is outside the warranty period and if it is not a latent defect, then you will have to repair it on your own. Unless you can bring in a third kind of defect, which is called structural defect. Structural defects are not covered by the warranties. Warranties cover all the other things. But if you can prove that there is a structural defect, then you may still be able to bring an action against the developer. All right. So that is what you can do when you're talking about your own property, your own unit, your own parcel, and there are damage or defects in your own unit. Further to this, I must also draw your attention to the fact of your sale and purchase agreement. If your sale and purchase agreement is the mandatory one under the housing rules, and yours is a residential, so it comes under the housing rules, it's standard sale and purchase agreement, then there will be a clause in the agreement whereby the developer actually gives an undertaking that the materials to be used will satisfy certain requirements. Now, here we need to look at the nature of the damage that is suffered or the defect that is incurred and the price that you pay for your unit, the marketing brochures that were issued by the developer, what are the kinds of representations that they give. If they tell you it is luxury condominium of the highest quality, and then you find that they have used some cheap material, then you may be able to bring an action against the developer on the ground that the materials used are not satisfactory. For example, certain parts of the unit may have to be given an undercoat which will prevent fungus from developing. There would be a need for waterproofing to be done for bathroom floors before tiles are put. And if this is for newer units, old units will not have that. And if after that you find that the floors are leaking, your own units are leaking, causing damage, and you find that when you call the contractor tells you, oh, there was no waterproofing. Of course, you can bring an action against the developer based on the undertakings which are given in the sale and purchase agreement. Right? Now, moving on to the second situation where you have problems caused by your neighbors either above you or below you. In these kind of situations, once again, I must emphasize the Strata Management Act does not provide for you to bring an action against a fellow parcel owner. So if you look at the Strata Management Tribunal, where it says who can bring an action and against who, you will find that there is no provision for a parcel owner to bring an action against another parcel owner. So this is the tricky part. You can't sue your neighbor directly in the tribunal. If at all you want to sue, you will have to go to court. And if your claim is less than 5,000, then automatically you will have to sue them in the small claims court. And if you're an individual, you cannot be represented by a lawyer. If the owner of this parcel is a Sindrian Berhad or a Berhad, they can be represented by a lawyer. Because the rules of court 2012 provide that a corporate body must always be represented by a lawyer. So you may have a funny situation where the plaintiff is an individual, the defendant is a lawyer, the defendant is a company, defendant parcel owner. So the defendant will be represented by a lawyer, but the plaintiff cannot be represented by a lawyer. It's a very tricky situation. Now, of course, if your claim is more than 5,000, you can bring an action in the magistrate's court if your total claim does not exceed 100,000. Most claims will be less than that, unless you can prove that there are special items that have been damaged as a result. Okay? Now, this is a first tricky situation. So, what do you do if either your wall is leaking or your ceiling is leaking? You will have to make a complaint to the managing body, which is either the JMB or the MC, or may even be the developer for that matter. Depends on what stage of management you're in. Remember, there could be 3 stages of management: the developer's management stage, the JMB management stage, or the MC management stage. So, depending on whether it's a developer management stage, JMB, MC, you lodge a complaint to them, right? And they are to undertake the investigation. If you have with you your Strata Management Act, you can look at the Strata Management Maintenance and Regulations 2015. And regulation number 57 says any developer, joint management body, management corporation, etc., shall, as soon as practically possible or within 7 days from the date of receipt of notice given under Regulation 56, carry out an inspection. So, Regulation 56 requires you to give a notice to the managing body, and within 7 days, they are required to come and carry out an investigation. This is in particular to interfloor leakage. Interfloor leakage. What is the purpose of the investigation? Is to determine the cause of the interfloor leakage and the party who shall be responsible to rectify that defect. Okay? Now, in the past, it was very difficult to determine, even if there was a leakage from your ceiling, there's an interfloor leakage, it was very difficult to determine who is the actual cause of the leakage. But now we have Regulation 58, which says that there is a presumption under Section 142 that if there is an interfloor leakage, the presumption is the leakage comes from above. Okay. That's number one. Number two, also in Regulation 58, there may be, if there's a defect in the water meter, water pipes, drainage pipes, etc., and this pipe or the duct that is leaking serves more than one unit, it means the leakage is from the common area. So two presumptions. One is if the leakage is from above, interfloor leakage, it means that it is caused from the floor above. Number two, if the duct or the piping or the meter runs to more than one or serves more than one unit, then it is presumed that the leakage comes from a common area. Now, for purpose of interfloor leakage, of course, the management body will have to enter into premises to inspect. Regulation 63 very clearly says that the owners cannot refuse entrance. It is an offense to refuse entrance. So the managing body can enter for purpose of inspection. Now, this is all very, very tricky. What if it is unoccupied unit? Can the management body break in? Answer, if it's an emergency, yes, they can break in. They can enter without permission. If it's not an emergency, they should obtain permission to come in. So there are guidelines there. Once they complete their inspection, they are supposed to determine who is responsible for the leakage. And then they are supposed to do the necessary repairs. Instruct them to do the necessary repairs. So if the leakage is caused by the owner above, maybe the owner go and redo the tiling of his floor.
According to NA.
So if they do what we call a recording, sorry for that. Let me silence the phone. Okay. If the owner has gone and redone the floor tiling, and as a result, this is the cause of the damage to the floor below. This is what caused the interfloor leakage. Obviously, the owner has to repair. If the owner has dropped very heavy things on the floor and this has caused the damage, the owner has to repair. The managing body will have to give the necessary orders to the owner to repair. If the owner refuses to repair, then the managing body itself can carry out the repairs, and then they will charge the owner who is at fault. If the managing body discovers that the leakage is caused by defective workmanship or that it is within a defect liability period, then you must make your claim against the developer. You can find this in regulation 60 down there. Okay. So this is what happens. Now, the form that you must use is form 28. Please take note. You use form 28. Right. Next is what we call a party wall. Party wall is covered by regulation 65. Okay? So party wall is a wall that separates one parcel from another parcel or a parcel from the common property. I want to draw your attention to one thing. If you have your act with you, look at regulation 55, which talks about interfloor leakage. Regulation 55, which talks about interfloor leakage, mentions here interfloor leakage means evidence of dampness, moisture, or water penetration. Three things only. There's no etc. etc. there. Only three things: dampness, moisture, or water penetration. That's interfloor leakage. Now, for party wall damage, party wall, it says here in 65, okay, 66, sorry. Evidence of dampness, the same as earlier. Moisture, same. Water penetration, same. Or other damage. Or other damage. This means that party wall damage is broader than interfloor leakage. Interfloor leakage is only dampness, moisture, water penetration. Please note, it doesn't even say liquid, water penetration. Whereas interwall or party wall is dampness, moisture, water penetration, or other damage. And not only that, going back to Regulation 55, you must read carefully. This damage and also to the party wall, the damage can include furnishing material, including plaster, panel, gypsum board, attached, glued, laid, or applied to the ceiling, right? And the same thing applies to damage to party wall. Furnishing material, plaster, panel, gypsum board, right? That forms part of the interior of a parcel. Okay. So this is what is done in the first place. And this is how things are supposed to be dealt with. Now, the problem is this. Depending on which side of the fence you are in, if you are the victim, meaning you are the owner of the parcel that is experiencing the damage, you have a choice. You have to complain to the JMB or MC. If the JMB or MC does not do anything within the 7 days, you may have to bring an action against the JMB or MC for failure to carry out their duty. So now you got a double problem. Not only do you have a person who causes a defect, you have a JMB or MC which is totally ineffective. The MC may come and find that the person causing the damage is very uncooperative, refuses to carry out any repairs, and so you'll find that you continue to suffer. So either you compel the JMB MC to repair the damage and charge the wrong party, the defaulting party, for it. By doing that, you shift the entire thing to the MC or the JMB. You repair my place, you charge. It's not my problem. So it's something like insurance style. My car is damaged, all right, it's not my fault. The other guy hit into me. I claim against a third party insurance. Let them pay for it. How you deal with your own client is your business. But if the MC or JMB refuses to do so, then you have to bring an action in court against the other owner. Remember, you cannot bring an action in the tribunal against a fellow owner. There are some instances where the JMB may not have funds to repair, especially at lower end properties. So what do you do in such a situation? This is the kind of problem that you may face. If the owner of the defective property, of the defaulting property, plans to sell the property, maybe you threaten to sue the purchaser and say, you are inheriting a nuisance. Because the vendor is causing the nuisance, he's selling the property to you, you are inheriting the nuisance, I will sue you. So you create a bit of problem between vendor and purchaser. But basically, these are your rights, these are your remedies. You may complain to the Commissioner of Building, please note. You can complain to the Commissioner of Building. You can state that the JMB MC is not doing its job or the owner is not repairing. The Commissioner will come and make their own inspection, and then the Commissioner may instruct the owner to repair. But the Commissioner cannot compel the owner to repair. For you to compel the owner to repair, you need to go to court and get a court order. All right, so generally, this is the situation we find ourselves in. Complain to the JMB MC. If the JMB MC acts, fine. If they do not act, compel them to carry out the repairs and charge the party at fault. If not, go to the Strata Management Tribunal to compel the JMB to carry out the job, in which case the JMB becomes your enemy. If you want to sue the owner directly, you need to go to court and file a suit against that person. If your claim is less than 5,000, small claims matter, then you cannot be represented by a lawyer. But if your claim is even slightly more, let's say you are claiming 10,000 repairs, you will need to ask, is it worthy to get a lawyer to go and repair it for you? You must understand, the court will not award you the cost that your lawyer will charge you. The court only awards general cost. So at a magistrate's court level, you may get 5,000, 6,000 cost. You may have paid about close to 10,000 to your lawyer, cost plus disbursements. So you may be wondering, is it worth doing it? This is the tricky part that we need to face here. All right, I'll stop here for the moment. And thank you very much for listening. And I believe this will be the next half an hour or so, will be a bit of question time, which we hope to be able to answer some of your questions or give you some directions as to what you can or may do. Thank you very much.
Okay, thank you so much, Mr. Patrick. I hope everyone do gain some input and better understanding about this topic. And now we are moving on to our Q&A session, which I can see there are some questions coming from the participant tonight. And I will pick one of the questions coming from Yat WC. Does Limitation Act covers the latent defect on interfloor leaking? I pass to you, Mr. Patrick.
All right. Now, yes, from the time you discover your defect, of course, the general rule on limitation against any defect on interfloor leaking comes under the law of torts. And since it comes under the law of torts, you're given 6 years in which to file your action. Now, the problem could be that the origin of the problem might be more than 6 years. It's very possible that water could have gathered somewhere between the floors. Depending on the structure, the water may not actually, because you may get situations where water leaks. First, you can see your plaster ceiling is getting damp. Then you can see all kinds of fungus building up on your plaster ceiling, and slowly, little by little, holes start appearing. Now, if that is the case, then from the day it starts, you have 6 years. Sometimes, however, for some reason, the way it's structured, the water may be gathering there without you knowing it, and suddenly one day, bang, the whole thing collapses. In which case, you will say this is latent defect because there was not a single sign showing any defect. You still have 6 years, but if you can show that it is latent defect, then you may be given an additional 3 years. If I'm not mistaken, I need to check on that. An additional 3 years to bring your action from the date you discover the latent defect. Right? So first you must prove that it is a latent defect, something which appeared late. Number two, you will have to bring it within that extra time that is given to you. Thank you.
Okay, thank you, Mr. Patrick. Moving on to our next questions, I will choose. Hold on. Um, from I'm sorry because there's a lot of question right here. So from Kelvin Chong Sengfu, Sir, how could I make a claim under SPA third schedule? 5% purchase price to be held by the developer solicitor as stakeholder during the 24 months DLP. If the solicitor as a stakeholder refuse to pay the compensation, what shall we do? How shall we complain in Bar Council of or KPKT?
All
Pass
right.
to you.
Okay. This is a very interesting question to ask. You can, of course, report to the bar council, but very importantly, first and foremost, is to find out from the lawyer, the stakeholder, why he is refusing to pay the compensation. It could be that the developer has instructed him not to pay, or the developer denies that there is such damage. It could be denied. So if you are not satisfied with that, then you can make a claim at the KPKT, no problem. You can also lodge a complaint with the COB on this point, since it comes under strata properties. I think to complain to the bar council or the disciplinary board will only arise as a last resort if they're genuinely you are entitled to the money and they are not releasing the money to you, right? So otherwise, you can make the necessary complaints to the KP, to the Kementerian Perumahan, because it's under their law that this money is being held. Thank you, Mr. Kelvin.
All right, thank you, Mr. Patrick. I hope it could answer the questions just now. And next question will be from Jessie Koo. Good evening, Mr. Patrick. If the parcel already more than 15 years, the leakage from the balcony inner floor to the lower floor unit, whose responsibility for the repairs?
Okay, now when you talk about the balcony, there's two possibilities. One is that it is a natural effect as a result of the structure, right? If it's an exposed balcony, obviously when it rains, water is going to hit in it. And there should be proper drainage for the balcony so that the water can be drained out without causing further damage either to the unit itself or to the floors below it. Now, secondly, it is possible that the leakage is caused because a lot of people like to plant flowers in pots and leave it in the balcony. Um, you may have some people who put roses down there, some people who like to plant bougainvillea flowers, right? Personally speaking, I like the roses, I like bougainvilleas, I like to put Christmas trees. Of course, Christmas trees are too big to be put in balconies, but in my case, I stay in a landed property, so it's okay. Bougainvilleas can be a problem because after they flower and the flowers wither, they all dry up and they cause a loss of rust and they may block the drainage in the balcony. And if this is the cause, you see, they always say water will find it will always, let me correct that, water will always find its own exit and water will always find its own levels. So, water gathering at the balcony means the water is actually, think of the water as being something alive which is being trapped. It is now trying to find its way out. The water outlet, the drain, should be the proper channel. But if it is blocked, the water is going to find its way out. It's going to find some minor crack in the balcony hole somewhere, maybe the tiles or what, and it will slowly seep little by little. Over a period of time, it is going to go down and cause damage. In such a case, the blame will lie squarely on the owner of that unit. They will be responsible for repairing. As I said, The JMB or MC may repair it, charge it against them as well. That is why, in actual fact, uh, people should be discouraged from planting or putting flowers on their balconies because it will cause this kind of problems. Thank you.
Okay, I understand. Such a well explained. Okay, so moving on to the next question from Hamidi Midi. Is a developer still liable to rectify defects that appear way after the defects liability period (DLP)? I'll pass to you.
Okay. Now, the answer to this question, I think I mentioned earlier that you have to look at the nature of the defect. The nature of the defect could be one of three things. One is it's just one of the quality of things which are very poor. These will be covered by the defect liability period. Paintwork with fungi appearing, all this will be covered during the defect liability period. Two will be latent defects, defects that only appear after some time. Then there could be extension of time granted for you to make an action, to bring an action against the developer. Right? Now, while the defect liability period, we need to understand a defect liability period is contractual as part and parcel of your sale and purchase agreement as mandated by the housing developers rules. But defects, latent defects, are under the law of torts or law of negligence, whereby due to the negligence of the developer, some defects are latent and appear much later. Of course, the longer it takes for the defect to appear, the less likely it is going to be the fault of the developer. It could be some other fault. Now, in one case in 2021, January 2021, Justice Lim Chong Fong distinguished between structural damage and damage arising as a result of poor maintenance. Now, the defect for which developer is liable is going to be structural damage or damage arising during the defect liability period. However, if the defect is a result of poor maintenance, obviously you cannot sue the developer. You will have to sue the people who are responsible for maintenance. Maybe the damage to your property arises because there is poor maintenance of common property. Let's say party wall. You're talking about your wall getting damaged because of poor maintenance of uh, the external part of the wall. And we know the external part of the wall, the facade, is to be maintained by the developer or the persons in charge of management, JMB or MC. So when the MC gets the building painted, they must use suitable paint, weather shield or weather bond, paints like that, which stands against rain and shine. If, as a result of trying to cut costs here and there, the JMB or the MC uses some kind of cheap paint, and then the paint cannot withstand the weather, poor weather, water seeps in and causes damage through the party wall to your inside wall. Suddenly you see your wall got fungi, the paint is all cracked, there's moisture. And when you check with your contractor says because the outside wall was not painted well. This is poor maintenance. You can't sue the developer, you need to sue the JMB or the MC. That's the purpose of a sinking fund. The sinking fund is to do paintings to the building, major repairs to the building. That's why you pay the sinking fund, and the sinking fund should be utilized for this purpose. Thank you. Thank you.
All right, thank you. I hope it answered the question just now. Next question is from Oi Sumin. If the floor leakage at the common area of ceiling, can the parcel owner have right to complain to COB if MC never take action to repair it? Apa
Yes,
sih?
of course. Yes, sorry. Thank you. Yes, of course. you can make a complaint. In fact, as we are aware, as a result of amendments to the law, the developer has to pay a certain percentage of the construction cost as common property defects account. And this money is to be kept by the developer and will only be returned back to the developer when everything is complete and there are no defects on the common property. This is a common property defects account. But I'm guessing that your question arises after the common property defects account money is already paid back to the developer. Now, then it will become an issue of maintenance. The law is very clear. It is the duty of the MC or the JMB to maintain the place, to maintain the common property. And if they do not maintain the common property, yes, every parcel owner can lodge a complaint with the COB. Yes, thank you.
Okay, thank you, Mr. Patrick. And okay, so next question is from Divine Saga Nivad. Good evening, Mr. Patrick. Just curious to know what happens if the top floor unit has a leakage due to a defect in the main roof of the building? Is it the responsibility of the unit owner to rectify the problem? Thank you.
All right.
Pass to you.
All right. There are many kinds of situations, but let me take about two. Some buildings have what we call rooftop gardens. And these rooftop gardens are considered as accessory parcels. So there are some people who buy a top floor unit solely because an accessory parcel called a rooftop garden comes along with it. If yours has a rooftop parcel, then obviously it is accessory, and if it is an accessory, it becomes the owner's responsibility to maintain and to repair it. On the other hand, if there's no such rooftop garden, it just has a roof. That roof is common property because it's supposed to cover everything, and therefore it is a responsibility of the JMB or the MC to repair it. You need also to look very carefully at your sale and purchase agreement and your deed of mutual covenants to see whether the rooftop is part of your accessory or whether it is common property. If it is an accessory, it will be mentioned in your deed of mutual covenants. If not, it will be the JMB's or MC's responsibility to maintain it. Thank you.
Okay, thank you, Mr. Patrick. Next question is from TF Tan. Mr. Patrick, what can the management do if the owners default on their monthly maintenance and sinking fund, even after giving multiple reminders which cause poor upkeep of the condo due to insufficient funds? Into you.
Okay, this topic is a bit, this question is a little bit out, but still, I think the Strata Management Act has given sufficient powers to the JMB and to the MC to take the proper remedial action. One is to sue the owners in the Strata Management Tribunal for this amount. And once you get a judgment in your favor, you can then enforce it in the High Court, just like a High Court order. Number two, you can get written consent from the COB and seal the premises. And if after sealing the premises, the owner still does not pay up, you can sell off the items in the premises. Television, radio, handphone, you need to itemize all the items there and then you can sell it off. This can be done with the permission of the COB. 3. If the place is being rented out and there's a tenant staying there, the law provides that the JMB can garnish the rental. In other words, order the tenant to pay the rental to the JMB or the MC and regard that payment of rental as part payment of the maintenance charges, and also consider, and I mean it's part of the, that means instead of paying there he pays here, that's all. This is garnishing. This can also be done. Under the Strata Titles Act, you could only seal the premises of the owner. You can only seize any of his personal assets within that particular project development. But under the BCPA in 2007, it was extended to any other property within the district. So if the owner of the unit has got 2 or 3 apartments or condos, you can even go to other condos within the district and seize the assets there. Now, under the Strata Management Act, you can seize any assets within the state. So, if you're talking about a property in Selangor, you just have to go and find out whether this owner has other assets within the state of Selangor. If he has other assets, if he's not staying there, obviously he must be staying somewhere else. He must be having some other assets. You can go and seize the assets in any other part. Some of you may remember in 2018, 17 and 18, the COB for Kuala Lumpur went to 7 or 8 properties in Cheras together with the JMB and MC, and they went and sealed the properties in a number of places where people were owing a high amount of maintenance charges. So, sufficient remedies are provided in the Act for the JMB or the MC to take action. Whether they want to do it or not, of course, that's another question. Right? If this continues, actually, you can apply either to the COB to appoint a managing agent to manage the place, or you can apply to the court to appoint an administrator to carry out this job. An administrator can only be appointed when there's an MC in place, not when there's a JMB. So court can appoint an administrator, ask them, you all manage the place, since the JMB is so inefficient in what they are doing. Thank you.
Okay, thank you, Mr. Patrick. So we have another 5 more minutes before we end the session. I'll choose from the next question from Silence Moon. Mr. Patrick, we have some issue with the management where they, the management team, create a corporacy company and the apartment job, for example, cleaning, maintenance, are given to the corporacy company. Do this consider as conflict of interest? Can you advise what action should we take? We already report to COB and even bring the issue to tribunal. Yes, I pass to you,
All
Mr.
right.
Patrick.
Now, we have several cases where it clearly states that the duty of the developer, the duty of the MC, and the duty of the JMB are not delegable. In other words, they cannot pass it to somebody else to carry out the job. They may appoint employers, they may appoint property agents who are licensed to manage the place on their behalf. But if you say the MC itself forms a corporacy, the question that has to be asked is, where did the MC get the power to form such a corporacy? The powers of the MC are derived from the statute, and therefore, clearly, the MC is acting outside their powers when they do so. Now, in the case of Equity Setegap, case called Equity Setegap in Bangsa, what happened was there is a row of shops, and there's a row of shops at the back. One single purchaser bought all the 5 shops. all the 5 or 6 shops in the back row. And so they entered agreement with the developer saying, we will manage the place on our own. So cleaning, maintenance, all we'll manage on our own. You all manage in front. But just as a token, every month we'll give you 1,500 as our contribution. When the JMB was later formed, the JMB imposed charges on these people, and these people came out of their defense and said, look, we are maintaining this place on our own. We already have an agreement with the developer, and uh, we are paying 1,500 every month. Now, the court asked these questions. First question is, what gives the right to these people to manage their own property? In a strata property, is a developer manages JMB MC. If you have a subsidiary management corporation, then they will manage. But there's no provision for strata property owners to manage their own property. It has to be managed on their behalf by the JMB or MC. So that's number one. Number two, they said you have a maintenance fund, you have a sinking fund. What is its 1,500 contribution for? The MC or the JMB cannot collect any money outside the statutory provision. So the laws are quite clear. It's my view that the MC does not have power to go and create a koperasi company. That is wrong. I am currently having a case in Ipoh where one of the issues is exactly this. The developer has a subsidiary company which is managing the place. Even after the JMB came into existence, that subsidiary company continued to manage the place. So we have challenged this in court. The developer, when he is the manager, when the developer is managing, they can appoint anybody they want to manage. But once the JMB comes in or the MC comes in, they need to manage the place. That's why the Act provides for personal liability, where the JMB committee members or the MC committee members fail to carry out their duty, they are personally liable. So, the answer to this question, the advice is MC has no such power to do it. I'm not sure, the COB may not make any decision. I do not know whether the tribunal has the power to make such a decision. I think this must go to the court. Only the court can make such a decision regarding the koperasi. Thank you.
Okay, thank you, Mr. Patrick. I hope this answered the question just now. All right, so I think we don't have that much time. So that's the end of our session today. And for the questions that we didn't manage to answer, we will answer in the comment section or on the next episode. All right, so thank you so much, Mr. Patrick. I think that is all for tonight. And thank you everyone for joining our talk show tonight. I hope Mr. Patrick answered all your questions and have a clear view on this topic. Before I end this session, I would like to invite everyone to join our upcoming seminar, which is on the 11th December 2021, with the topic of Managing Defects and Disputes in Strata Properties by Mr. Patrick as well. Okay, so if you are interested to join this seminar, you can contact our number as stated below, 017-856-2228. I repeat again, 017-856-2228. And you can register with us. So that's the end of our session tonight. Thank you, Mr. Patrick, and thank you, everyone. Have a good night.
Thank you. Thank you. Good night,
All right.
everyone. Take care.
Thank you.
Stay safe.
You too. Stay safe.